Okay, let's unpack this. Welcome to the deep dive where we try to cut through the noise and figure out what matters most from your sources. Today, we're diving deep into a really fascinating and frankly incredibly complex corner of early American history and legal jurisprudence. We're drawing heavily from Jill Norgren's insightful work, Cherokee Cases, Two Landmark Federal Decisions in the Fight for Sovereignty. Now, this is definitely material for those of you already kind of wrestling with the nuances of U.S. Native American relations, the origins of federal Indian law. Our mission really is to explore two pivotal Supreme Court decisions. That's Cherokee Nation v. Georgia and Worcester v. Georgia. We want to look at the detailed legal arguments, the intense political context, and the surprising, sometimes contradictory outcomes that really set the stage for centuries of legal struggle. And following the source material's lead, we're actually going to start by examining the powerful statement made in the second of these cases, Worcester v. Georgia. We'll kind of rewind to understand the decades of history, the legal maneuvering that led to that moment, and crucially, what happened next.
Yeah, and what's truly fascinating about these cases, I think, is how they reveal the Supreme Court, even back then, grappling with these monumental questions. Sovereignty, property rights, the very place of Native American nations within this burgeoning United States. It's like Tocqueville famously noted, right? Scarcely any political question in America avoids becoming a judicial one. And these sources really underscore that. You see the high court's docket reading almost like a social and political history. The Cherokee cases are just such a prime example, offering this window into the fate of Native Americans in the early 19th century, all through the intense pressure cooker of legal disputes.
Okay, so let's jump right into Worcester v. Georgia, 1832. This one's often cited, isn't it, as the strongest judicial defense of tribal sovereignty during this whole period. It really came out of Georgia's escalating campaign to just assert complete jurisdiction over Cherokee territory, basically trying to erase their ability to govern themselves. And Georgia wasn't subtle about it. They passed laws, explicitly targeting anyone, especially white people, living in Cherokee country without a state license and oath. The aim was pretty clear. Dismantle Cherokee authority, force removal.
Exactly. And the figures who really brought this to a head were Samuel Worcester and Elizur Butler. They were missionaries living and working among the Cherokee, and they had federal and Cherokee permission to be there. They saw Georgia's laws as a direct violation of both Cherokee sovereignty and federal authority, so they consciously refused to comply. They basically used their own arrests and convictions as the vehicle to challenge Georgia's actions right up to the highest court.
So this test case makes it to the Supreme Court. And March 3rd, 1832, Chief Justice John Marshall delivers the majority opinion. He's joined by Duval, Story, Thompson. And this decision is, well, it's really significant. It's a robust legal affirmation of Cherokee sovereignty.
It really is. First, Marshall tackles the jurisdiction question, which, coming just a year after Cherokee Nation is pretty interesting. He ruled quite unequivocally that the court did have appellate jurisdiction to hear this case.
And the reasoning there?
Well, because the plaintiffs, Worcester and Butler, were U.S. citizens, and they were challenging a state law's constitutionality under the Supremacy Clause. The source highlights that Marshall seems to deliberately use this moment to reiterate the court's appellate power, its duty to review state laws, almost like a pointed reminder after the previous year when they declined original jurisdiction.
Okay. And the core legal outcome. What about those Georgia laws?
Struck them down. Marshall declared the Georgia laws under which they were convicted null and void. Why? Because they were repugnant to the Constitution, laws, and treaties of the United States. So that was a clear legal defeat for Georgia's immediate attempt to impose state authority inside Cherokee territory.
But you mentioned the deeper significance, especially for Native American rights. Marshall really dug into the Cherokee Nation's legal and historical status itself, didn't he?
He absolutely did. Marshall's opinion is, well, it's a deep dive into the history of relations. He traces it back to agreements with Great Britain, then meticulously analyzes U.S. treaties with the Cherokee. He specifically cites Hopewell, 1785, and Holston, 1791, his argument. These weren't just temporary deals, they were evidence that the U.S. had consistently recognized the Cherokee as a distinct political community, a community with the right to self-government within their own defined territory. And the source notes Justice Story, who was a really strong advocate for Indian rights, apparently encouraged Marshall to use this case, to lay out the most definitive statement possible on tribal sovereignty at that time.
It feels like he was kind of refining or maybe clarifying his own ideas from the Cherokee Nation case the year before.
He was, yeah. While he still didn't call tribes foreign nations, he definitely elaborated on and refined that domestic dependent nation concept. The critical point he hammered home in Worcester was that Indian nations had always been considered quote, distinct, independent political communities, retaining their original natural rights as the undisputed possessors of the soil.
Hmm.
And he borrows from international law here, specifically Vattel, using the idea that, look, a weaker power doesn't just forfeit its independence or right to self-government simply by placing itself under the protection of a stronger one. As Vattel put it, protection does not imply the destruction of the protected. That's a really powerful legal framing, isn't it?
It is. And
Mhm.
he directly addressed how treaties should be interpreted, pushing back against Georgia's narrow readings.
Yes, exactly. Marshall argued against twisting phrases where the U.S. assumed rights like managing all their affairs into meaning a total surrender of Cherokee self-governance. He argued those phrases related primarily to external things, like trade, not internal government. He called the contrary interpretation a perversion of their necessary meaning.
And maybe most subtly, but really significantly, the source points out that Marshall, without ever naming the case, seemed to implicitly walk back some of the more, let's say, problematic language from his own earlier decision. Johnson v. Emmentosh from 1823.
Right, and this is where the nuances get really critical for understanding the trajectory. In Johnson, you had that controversial dictum, a non-binding observation by the court about European discovery, giving rights almost like conquest. Well, in Worcester, Marshall states it was extravagant and absurd to suggest discovery conferred rights that just annulled the pre-existing rights of native inhabitants, he clarified. Discovery only gave European powers, and then the U.S. the exclusive right to purchase the land if tribes were willing to sell.
So not a right based on conquest.
Exactly. It wasn't derived from conquest or some simple annulment of Aboriginal title. He even added that the power of war is for defense, not conquest, and taking land by aggression wouldn't be recognized. The source reads this as a significant effort by Marshall, maybe trying to mitigate some of the damage done by the language in Johnson, language that states like Georgia had eagerly seized upon to justify their actions.
Okay, so Worcester is this incredibly strong legal affirmation. Cherokee sovereignty, rejection of Georgia's laws. But to really get why it didn't stop what came next, we need to step way back.
Right.
Like, look at the deeper history, the policy roots of this whole confrontation.
Absolutely. You just can't grasp the significance of these court cases without understanding the ground they were built on. I mean, the sources make it crystal clear. North America wasn't some empty wilderness. It was a populated continent shaped by complex, sophisticated Native American societies for millennia. Think about expeditions like De Soto, Luna, Pardo in the 16th century. That, plus archaeological evidence, shows dozens of interconnected, independent societies, kin-based, intricate political, economic structures.
And the early European interactions, they varied quite a bit depending on who showed up and why.
Precisely. The Spanish, initially driven by riches and converts, often leading to destructive encounters. The English, later more focused on permanent colonies. Trade. Though early attempts, like San Miguel de Gualdape, often failed. But crucially, in this early period, it was the Native American nations who dominated. European settlements were just these tenuous footholds, often totally dependent on indigenous tolerance and help. Early maps, the sources point out, show the continent lit up with names of major tribes and confederacies. European settlements are just marginal marks.
And the Cherokee themselves initially weren't a centralized state like in Europe, but they were definitely a distinct political community.
Oh, absolutely. An ethnic group, specific territory, bound by blood ties, shared culture, mutual defense, unwritten clan law. They had systems for resolving disputes, interacting with outsiders, but yeah, no large formal state apparatus in that very early period. However, they went through this huge transformation, particularly leading up to the time of these cases.
What drove that transformation?
Well, a mix of things, notably increasing interaction and, frankly, pressure from the expanding United States. Over the late 18th, early 19th centuries, the Cherokee Nation developed institutions of national government. There was a shift away from just the fur trade towards farming, animal husbandry. This economic shift helped foster the rise of a mixed-blood elite within the nation. They got into commercial ventures, adopted practices like owning slaves, and, importantly, played a key role in centralizing political authority.
Which culminates in that huge step, adopting a republican form of government.
Exactly. 1827, the Cherokee Nation writes and adopts a written constitution, modeled explicitly on U.S. state constitutions, bicameral legislature, court system, legal code. The sources note this was praised up north as proof of their civilization. But for Georgia, it was seen as a direct challenge. It created this renewed sense of threat because it showed the Cherokee were sophisticated, determined, and capable of defending their lands and self-governance through legal and political means.
And they were smart about communication too, weren't they? Using media strategically.
Yes, the creation of the bilingual Cherokee Phoenix newspaper was absolutely crucial. Using Sequoia's syllabary, it was funded by the Cherokee government. It served as this mechanism for public education, shaping opinion within the nation, and articulating their political stance against removal, against Georgia's aggression. It tells you something that the Georgia militia eventually seized the press in 1835. They recognized its power as a tool of national resistance.
So this evolving Cherokee national structure runs smack into the development of European and then U.S. legal frameworks for dealing with indigenous peoples.
Indeed, European legal thought initially really struggled with the status of non-Christian peoples, drew on medieval ideas, but it evolved, right? Towards the Law of Nations thinkers Vittoria, Grotius, Vattel. These scholars started classifying indigenous communities as sovereign nation-states capable of making binding treaties, recognizing their inherent political rights.
And early U.S. federal policy tried to sort of navigate this complex landscape.
It tried. You have the Northwest Ordinance of 1787, for instance, declaring utmost good faith towards Indians, lands not taken without consent. The Articles of Confederation attempted to centralize authority over Indian affairs nationally, but states like Georgia, New York, North Carolina, they largely ignored it, pursued their own land deals, their own initiatives, often sparking conflict.
The U.S. Constitution tried to clarify federal authority, gave Congress power over commerce with tribes, barred states from making treaties.
It did try, but states like Georgia kept pushing. Georgia had huge ambitions, claimed vast western lands, modern Alabama, Mississippi, lands crucial for agriculture, speculation, buffer zones. They ratified the Constitution, sure, but with the strong expectation that the new federal government would actively back their land claims against the Cherokee and Creek.
But President Washington didn't just play along with Georgia's plans immediately.
No, he complicated things significantly. The 1790 Treaty of New York with the Creek leader Alexander McGillivray. Washington affirmed Creek land rights, guaranteed contested boundaries within Georgia's claimed territory. That effectively slammed the brakes on Georgia's immediate expansion plans. And it sowed this deep mistrust among Georgians towards the federal government and its Indian policy.
And Georgia made a very conscious economic and political choice around this time that really shaped its future trajectory.
Yes. By the early 19th century, Georgia's political class was pretty much united. Their prosperity, they believed, rested on white cotton cultivated by black labor on land that would be taken from Native Americans. This solidified support for slavery in the state, and it demanded an aggressive expansionist state Indian policy, one designed to prod and sometimes counter federal policy.
Which brings us to a really crucial agreement that sort of laid the groundwork for future conflict, the Compact of 1802.
That was pivotal. Georgia ceded some western lands of, let's be honest, dubious title, anyway, to the U.S. in return. The U.S. government promised to extinguish Cherokee and Creek title on Georgia lands as soon as possible, and importantly, on reasonable and peaceful terms. This promise, the source points out, became this huge point of contention later. Georgia got increasingly impatient with the pace of federal treaty negotiations, especially as the Cherokee actively resisted removal.
And federal policy itself was starting to shift around this time, too.
Definitely. Washington's initial strategy leaned towards assimilation, right, encouraging agriculture, sedentary life. But the Louisiana Purchase in 1803, that fundamentally changed the game. Suddenly, there's this vast territory out west, seems like a convenient place to relocate eastern tribes. And the idea of removal gained serious traction.
And the Supreme Court itself played a part in shaping the legal concepts around tribal land ownership, even before the Cherokee cases specifically.
Yes, absolutely. Through cases like Fletcher v. Peck in 1810, and most notably, Johnson v. Emmentosh in 1823, it was in Johnson that Marshall introduced the Discovery Doctrine.
Right, the Discovery Doctrine, derived from European colonial claims.
Exactly. And this doctrine led to the idea of split title, or dual title, as the source calls it.
And what did that split title mean, practically speaking?
Well, it meant the European discoverers, and by extension, the U.S. as their successor, gained ultimate dominion over the land. They held what's called fee simple title, the highest form of ownership. At the same time, Native Americans were recognized as retaining a right of a mere occupancy and use. The source calls it a brilliant compromise. Because look, on one hand, it acknowledged and protected the tribe's right to occupy and use the land, implied it couldn't be taken without consent via treaty purchase, but on the other hand, it profoundly diminished their full sovereignty over the land in the eyes of U.S. law. It effectively claimed the underlying title for the U.S. government.
The source also suggests that Johnson v. Emmentosh wasn't entirely consistent internally and had some pretty controversial elements.
That's right. The source highlights that dictum about American conquest, which, as the source notes, was unnecessary for the actual legal holding of the case and historically questionable since much land was acquired by purchase. It also used these negative stereotypes of Indians as savage and warlike. So the argument is that while Johnson recognized Indian occupancy rights, by introducing the Discovery Doctrine and framing Aboriginal title as merely occupancy and use, it inadvertently gave states like Georgia justification. Justification to assert their own jurisdiction over tribal lands, seeing tribal sovereignty as fundamentally weakened.
Okay, so you've got this whole historical context, Georgia's specific land ambitions, the evolving U.S. policy towards removal, these earlier legal precedents. It all sets the stage for this inevitable clash with the Cherokee Nation, especially with the rise of Jacksonian democracy.
Andrew Jackson's presidency, starting 1829. Indian removal was its absolute centerpiece. The whole era of Jacksonian democracy saw this shift in American politics, right? Away from the earlier ideal of the virtuous gentleman citizen towards more partisan, self-interested politics, fueled by the huge expansion of voting rights for white men.
And Jackson himself had very firm, pretty uncompromising views on Native American tribes.
He really did. Jackson flat out rejected the idea that Indian tribes were sovereign nations. He saw treaties with them not as international agreements recognizing sovereignty, but just as pragmatic tools for managing relations. Convenient, maybe? He basically saw tribes as subjects of the United States inhabiting its territory. He believed the U.S. had unilateral authority over them and should just abandon the whole treaty system, legislate their removal directly.
And the motivations for supporting removal back then, they were widespread across the American population and quite varied according to the source.
Oh, they were complex. You had the deep-seated drive for national expansion, seen as continuing the post-Revolutionary War push to claim and settle the continent. There was also this powerful Western civilization mission, a kind of blend of secularized millennialism and ethnocentric evangelicalism. This idea that white Americans had a divine or historical destiny to fill the continent, bring progress. Indigenous peoples were seen as obstacles or just inherently lesser. The desire for land for white settlers was obviously a massive driver. Outright racism, too, this belief in the need for a racially homogeneous America, sometimes explicitly linked to movements like the American Colonization Society, and underpinning so much of it, the potential for immense profit and speculation from getting hold of valuable Indian lands.
This intense pressure cooker leads to that fierce political battle over the Indian Removal Act in 1830.
Yeah, it was a deeply, deeply contentious piece of legislation. Pro-removal forces just echoed Jackson's arguments. Tribes aren't sovereign, treaties are just conveniences, Indians are supposedly vanishing anyway, need to be moved west for their own protection. But the anti-removal voices, significantly amplified by figures like Jeremiah Evarts writing as William Penn, argued passionately against it, condemned it as violating international law, fundamentally breaking binding U.S. treaties. Despite that strong opposition, Jackson's political pressure was immense. The bill just barely passed the House, 102 to 97, 5 votes.
And the Removal Act itself, the language it used. The source notes it managed to cloak draconian measures in the sanitary language of governance.
Yeah, that's a good way to put it. It authorized the president to negotiate land exchanges, promising new lands west of the Mississippi, conveying title, compensation, aid. But the reality was, it set the framework for forced displacement, even if it was dressed up in terms of voluntary exchange. The source even includes this striking observation from a British writer at the time, noting the hypocrisy. Americans condemning European oppression while simultaneously driving indigenous peoples from their homes, in clear violation of their own treaties.
Right, so it was against this backdrop escalating state aggression, encouraged by federal policy, that the Cherokee Nation turned to the U.S. courts, leading to that first major case, Cherokee Nation v. Georgia, in 1831.
Exactly. Having strategically adopted American legal and political models, the Cherokee leadership hired top American lawyers. Former Attorney General William Wirt, John Sargent, prominent figures. Their objective was clear. Use the U.S. court system itself to protect the nation's political rights, its territorial boundaries, from Georgia's relentless intrusion, so they filed suit directly in the Supreme Court. Asked for an injunction, a court order, to stop Georgia from enforcing those anti-Indian jurisdiction laws, the ones that basically outlawed Cherokee self-governance within their own territory.
But the Supreme Court in Cherokee Nation, they didn't actually rule on the merits of the case, did they? They hit a roadblock.
No, they didn't get to the merits. Chief Justice Marshall's decision focused entirely on jurisdiction. Did the court even have the authority to hear the case as it was presented? And he famously held that the Cherokee Nation was not a foreign state in the way that term was used in Article 3, Section 2 of the Constitution. That's the part outlining the court's original jurisdiction in cases involving a state and a foreign state.
And that's where that incredibly influential and, well, later very problematic phrase came from.
Precisely. It was in this decision that Marshall classified the Cherokee Nation as a domestic dependent nation. He used that analogy. Their relationship to the U.S. resembled that of a ward to his guardian. He stated their territory was part of the U.S., and ultimately, he concluded the court lacked original jurisdiction to issue the requested injunction against Georgia's legislative power. He described it as asking for too much of the exercise of political power from the judiciary.
So a major legal hurdle for the Cherokee strategy right there.
A huge one, yeah. While the court didn't rule against their rights on the merits, denying jurisdiction meant that legal pathway, the one to directly stop Georgia's laws, was closed. For the moment, anyway. The source also really highlights the division on the court in this case. Justice Baldwin, for instance, wrote this concurring opinion reflecting a strong Jacksonian view, basically denying Indian tribes were genuine political communities at all. He argued vehemently against expanding Supreme Court power to intervene, insisted Georgia had full jurisdiction. He worried about opening the floodgates to endless controversies if tribes could sue states in federal court. Justice Johnson also concurred, finding no jurisdiction, but using more complex legal reasoning than Baldwin, even though Johnson had previously argued against Georgia's fee simple claim back in Fletcher.
But there were dissenting justices who saw it completely differently.
Oh, absolutely. Justices Thompson and Story wrote a powerful dissent, argued forcefully that the Cherokee were indeed a nation capable of suing, that the court absolutely should have heard the case on its merits. Their dissent drew heavily on the legal arguments Wirt and Sargent had presented, and the source suggests this dissent shows that, some justices intellectually agreed with the arguments for Cherokee sovereignty, but ultimately, political fear for the court's future stability, led Marshall and McLean to prioritize avoiding a direct political showdown with President Jackson and Georgia by denying jurisdiction.
Which brings us back full circle to Worcester in 1832. After that jurisdictional roadblock in Cherokee Nation, the case with the U.S. citizen missionaries offered a different path, one where the court's appellate jurisdiction was clear.
Yep.
So Worcester becomes the clear legal victory the Cherokee Nation had sought, affirms their inherent sovereignty, unequivocally strikes down Georgia's anti-Indian laws, but then came the critical, tragic failure.
Georgia just refused to obey. Simple as that. Refused to obey the Supreme Court's decision. This is that spark moment where the line between judicial authority and raw political will is tested and just broken.
And that infamous quote, usually attributed to Jackson, really captures it. John Marshall has made his decision, now let him enforce it.
Right. The source notes historians debate whether Jackson actually said those exact words, or, maybe more importantly, whether he would have felt legally compelled to enforce the ruling if the court had somehow framed an order demanding executive action. But what's absolutely clear is that Jackson was pleased. Pleased by the court's effective inability to coerce Georgia into compliance. The fundamental problem was the lack of a clear legal mechanism, and crucially, the lack of political will at the federal level to actually enforce a judicial order against a defiant state, especially when it came to Native American rights. The source points out William Wirt, after Worcester, actually proposed specific legislative fixes, things like giving federal judges power to issue writs to free people held under unconstitutional state laws, even amending the Militia Act to require the president use force if needed to uphold such orders. None of that happened, of course.
So the legal victory in Worcester, even though it was clear on paper, it didn't actually alleviate the pressure on the Cherokee leaders or even on the missionaries themselves.
No, it intensified it, in some ways. Despite the legal affirmation, some so-called friends of the Cherokee, even Justice McLean privately, started suggesting that continued legal resistance was basically futile, given the political reality. They urged the Cherokee to just accept a removal treaty, and this period saw deepening divisions within the Cherokee Nation itself. Figures like Elias Boudinot, Major Ridge, they increasingly felt, you just couldn't rely on the treaties, the Constitution, the laws of the U.S. to protect them.
And the missionaries, Worcester and Butler, they initially refused the pardons Georgia offered them, didn't they? Stood their ground.
They did. They didn't want the stigma of being pardoned culprits when the Supreme Court had ruled their convictions were void in the first place. They also feared, rightly, that accepting a pardon would undermine the significance of the Supreme Court's decision. undermine the reliance others could place on the court for protection against unconstitutional state laws. And this is all happening, remember, at the same time as the South Carolina nullification crisis in late 1832, another huge instance of state defiance against federal authority. Jackson's incredibly strong response to South Carolina preparing military force, it just highlights the stark contrast, doesn't it? Federal willingness to enforce authority when it came to tariffs versus when it came to judicially affirmed Native American rights. Very different responses.
Ultimately, though, the missionaries did accept a pardon, January 1833.
Yes, they did. Influenced by the Prudential Committee of the American Board, the group funding their mission. Their stated reasons were complex. They included the fact that the specific state law they were convicted under had technically been repealed, though other anti-Indian laws remained firmly in place. And they expressed this fear that continuing the legal battle would cause greater injury to our public, meaning the United States, by deepening the constitutional crisis. They felt that outweighed the ongoing abuse faced by the Cherokee. It's a really tough decision to parse, and their paths diverged after that. Worcester eventually came to support removal as inevitable. Butler continued to support Chief John Ross and the faction determined to resist.
And the grim, tragic aftermath is it's so well known.
Yeah.
The Trail of Tears.
Yeah. With legal avenues effectively closed by that lack of enforcement and political will firmly set on removal, the U.S. military was deployed, late 1830s. To organize the forced removal of roughly 17,000 Cherokee people from their ancestral homes in Georgia and surrounding states. This forced march, the Trail of Tears, it resulted in thousands of deaths. Disease, starvation, exposure, sheer brutality. People were driven from their homes at bayonet point, sometimes given just minutes to grab belongings. They lost almost everything. The source even notes the incredibly bitter detail that the fees for the American lawyers, Rate and Sargent, were eventually paid out of funds from the removal treaty itself. Money supposedly meant as compensation to the Cherokee Nation for their stolen land and property.
And they were forcibly resettled in Indian Territory, what's now Oklahoma. But even that wasn't the end of it, was it? The U.S. policy seeking dispossession and assimilation continued.
Oh, absolutely. After the Civil War, the U.S. government just kept pushing policies of land acquisition, tolerating white encroachment, passing assimilationist legislation, things aimed at dissolving tribal governments, ending communal landholding, imposing individual property ownership. It was relentless.
It's a direct, devastating consequence of the U.S. government failing to uphold its own Supreme Court's ruling in Worcester.
It really is.
So what does this whole journey, this decades-long story, culminating in these two pivotal and seemingly contradictory Supreme Court decisions, what does it all really tell us? We've traced this path from complex indigenous societies meeting European expansion, the Cherokee Nation developing sophisticated political and legal structures of its own, clashing with Georgia's relentless land grab fueled by cotton and slavery economics, navigating the turbulent politics of Jacksonian America, all filtered through the lens of the U.S. Supreme Court. You have Cherokee Nation denying jurisdiction, labeling the Cherokee a domestic dependent nation, then Worcester, just a year later, offering this powerful legal defense of tribal sovereignty that was ultimately rendered toothless by a lack of political will to enforce it. It's just such a stark example, isn't it, of the huge gap that can exist between legal principles and political reality.
Yeah, and if you connect this to the broader sweep of American history, these cases really highlight an enduring tension, don't they? The stated ideals, law, justice, treaty obligations clashing with this relentless, often brutal drive for territorial expansion and control. The sources show how fundamental legal doctrines were shaped, sometimes, frankly, twisted by political expediency, economic interests, prevailing cultural views like that secularized millennialism, that ethnocentric nationalism we talked about, and the very language used in these early landmark decisions, particularly what the source calls the equivocating language. It left room, didn't it? Room for later interpretations by courts, by Congress, that facilitated the continued dispossession and undermining of tribal sovereignty.
It really makes you stop and think. Given the complex, often painful history we've just walked through with these sources, what aspects of this deep dive stand out most strongly to you? What lingers?
Well, it raises this question that just continues to resonate today, I think. Considering these contradictory legal foundations laid by Cherokee Nation and Worcester, one acknowledging sovereignty in principle, the other introducing the ward guardian idea and contributing to this notion of unchecked federal plenary power, how much of contemporary federal Indian law still grapples with that fundamental tension, that tension between treating tribes as inherently self-governing nations and treating them implicitly or explicitly as dependent entities subject to overriding federal authority?
A deeply complex and enduring question indeed. This has been a truly deep dive into the foundations, very difficult foundations, of federal Indian law.